welcome today. I hope you are well. My name is Albert Mitton, and I'm with SMIEO, the employees organization. And yeah, it's a beautiful Thursday morning, at least up here in Pretoria. I hope it's not too bad that side of the world, wherever you may be joining us from. And I've got the privilege and honor today of just welcoming my esteemed colleagues who are presenting this webinar. So first and foremost, we have Claudine McPherson. She is an experienced practitioner in labor and dispute resolution. Sorry, everyone. I think someone's mic is unmuted. It's just a bit difficult to hear my thoughts. Thank you so much. All right, so let me start again. Claudine McPherson is a specialist in labor and dispute resolution for over 15 years and has previously studied in various other fields, including public relations and human resources, and she's currently busy with her 4th year of LLB. The other presenter is Caitlin Ntuli, also a highly experienced practitioner in dispute resolution in labor law, and she is an admitted attorney of the High Court. So I just want to once again welcome everyone. Thank you for joining us. We know your time is valuable, but I do think this is a very interesting webinar. Of course, the topic being managing workplace absenteeism, legal compliance, and practical solutions. Of course, irrespective of the industry or field or the nature of the business, I think we can agree this is one of the most common issues in any workplace, how to deal with absenteeism, what are the do's and don'ts. And yeah, without further ado, and also just before I introduce or hand over, at the end, we will, of course, have a Q&A. You are welcome to then ask questions in relation to this webinar. And please do ask any real-world problems you might be facing at the moment. Perhaps we can jump in and guide you in terms of those absenteeism issues you're currently facing. All right, so on that note, without further ado, I'll be handing over to the presenters. Thank you, ladies.
Thank you, Albert. Thanks, Albert.
You are most welcome.
Good day, everyone. We thank you so much for taking the time to join this webinar today. I believe that the topic that we're going to be discussing is something that employers struggle with on a daily basis. So we do want to just equip you guys on how to manage those last-minute absenteeism. We are going to touch base on how it affects your small businesses or operative or productive sensitive businesses, or where businesses where staffing is very important. So we're also going to talk about sick notes. We've seen it before where employers are submitting questionable sick notes. We want to talk about how to handle such situations, on how to foresee sick leave abuse, on how to handle it, traditional healers. People do say that they went down the road to a sangoma. We have to know how to handle that, so we are going to touch base on that, and clinic letters and pregnancy checkups. So please just know it's interactive. You can ask questions, you can raise your hand. I hope we can have fun today.
Yes, definitely.
So it's not in dispute that sick leave, it's a legitimate right for the employees. It's in accordance with the BCEA, the Basic Conditions of Employment Act. However, unmanaged absenteeism can place a significant strain on the business, particularly, like I said, small businesses or businesses where operation rely highly on staffing and production. So in this session, we aim to provide employers with, practical guidance, on how to manage the absenteeism lawfully, identifying the problematic, sick leave, and ensuring that the sick notes that are submitted by employees, they are compliant with the law. We believe that this topic is very important. Absenteeism is not just an inconvenience to the business, because it can have real operational consequences and financial consequences at that. An employee fails to report for duty on time, and suddenly the entire process or the entire production or the operation is disturbed. So especially for businesses that are in retail, construction, hospitality, absenteeism, they can be very, very sensitive. So we are going to touch base on that as well. We've seen it before as well, where employees submit, like I said, questionable sick notes, where you are left wondering, are you supposed to accept it? Is it legitimate or not? So what are the steps that you should be taking as the employer to make sure that you still stay within the boundaries of the labor relations, but also, managing it correctly for your business, fairly and consistently? Yeah.
All right. Thank you so much, Caitlin. All right. So let's first look at understanding absenteeism in the workplace. All right. So if we look at the first one, unplanned absences from work, when we look at unauthorized absence, you need to understand that an unplanned absence from work can take any form, either from somebody telling you they're going to the bank, or somebody being absent because they had to take their sick child to work, or to the hospital or to the doctor, or they've got a work emergency that they need to attend to. Whatever the case might be, unplanned absences in the workplace does happen, but we need to distinguish whether or not it's an unauthorized absence or whether the absence is regarded as authorized. That prerogative is obviously governed by the basic conditions of employment, the Labour Relations Act, and your policies that you have in the company. So that is the first thing that we need to look at when we look at absenteeism is it a planned or an unplanned absence? And is it authorized or unauthorized? So those are the distinctions that we need to look at. Then secondly, we look at the frequent short-term sick leave. I think this is a contentious issue that we face in a lot of employers, where they don't understand if it's a short-term sick leave, what is it regarded? Can we go through an incapacity process? Is it not an incapacity process? How do we deal with short-term sick leave in the workplace? Well, that is where we need the medical practitioner's assistance in that regard, so that we can understand and inform the medical practitioner in terms of what is the nature of the absence, what is the period of the absence, when can the employee return to work, and can the employee actually return to work after a specific period of time. Also, we need to look at things like, was it an injury on duty? Was the person booked off work? Was it based on an injury that he sustained at work? Was it a disease that he was actually obtained at work? Or what is the reason for this? So those are more in-depth issues that we need to look at, and that we will also obviously do at another webinar when we look at incapacity issues. Then also an important thing to look at is patterned absenteeism in the workplace. Can we show that the person over a period of 4 months is always consistently taking time off on a Monday or a Friday? And if so, then we need to start looking at progressive discipline in the workplace in terms of our disciplinary policy. So what does our policy say in regards to absenteeism on Mondays and Fridays? Does the policy require that you actually need to submit a medical note for those absences? Obviously, the law does say if a person is absent within an 8-week period, we can lawfully ask them to submit a sick note. But does our policy indicate something else? Is the policy written in accordance with the basic conditions, or is the policy more favorable for the employee or for the employer? So those are the type of things that we need to look at when we consider patterns of absenteeism. Obviously, when a pattern occurs, then the employers within their rights to have a counseling session with the employee to determine what is the causes of this, and then take further action as deemed fit. All right. Then absence without proper notification. This is also important because some people and employers actually, they start at a specific period or specific time throughout the day. So it's crucial for the person to be on shift when the shift starts either at 6 o'clock or 8 o'clock or 9 o'clock. Due to operational requirements from the company. So proper notification is a definite requirement in the workplace. That is something that we need to look at, and something that needs to be in the contract of employment or in your policy, so that the people are aware what is the requirement of the company. Do you need to notify the company an hour in advance, 2 hours in advance? And what is the policies and the procedures in terms of your company's rules? What do you require? For instance, if it's an admin environment, and the person is a receptionist, one would think that they would need to give you an hour's advance notice because somebody needs to pick up the phone. when you start. If it's somebody that's you know, a packer and picker, then obviously if they notify you by 8 o'clock when the shift starts, that will be acceptable. So it all depends on the operations of the business and what is your requirement. And that's why it's important to actually have a look at all these aspects when you actually draft your policies. Then another important point is absconsion and desertion. I think this is where a lot of people don't realize the difference between the two. They would use in some of the charges that we see as we go to different employers, that there are people that would say that the person absconded or deserted. You need to understand what is the difference between the two. So when we look at absconsion, that is the extended absence where the intention to return to the workplace is unknown. So somebody left the workplace on the Friday, they didn't come back the next week or the week after that. You have no idea where they are. You try to make contact with the family members. Nobody's aware of where the person is. Then it's an unknown absence. So that would be regarded as absconsion, whereas desertion is where the person was absent for 2 weeks. They left the workplace abruptly and said, I'm not returning to the workplace. And you can make the reasonable assumption that the person is not coming back. Or you were informed by a family member or another colleague that the person actually started working at a different employer. So that would also give you a reasonable understanding that the person has deserted from the workplace. So when you draft charges or you speak to your human resources specialist and you want to take the charge further, just make sure that you understand the difference between absconsion and desertion so that you don't get caught in a situation where you're in a disciplinary inquiry and the chairperson finds that the charge was incorrect. All right. Any questions so far? Please, as my colleague Caitlin indicated, that it is interactive, so please don't wait until the end of the session. If you've got any questions, please do ask us as we go along. All right, and then I think I did touch on this briefly in terms of your employer's policies. This is crucial for any employer because the development and implementation of a clear policy guides the employees as to what is expected, what is the consequences if they don't adhere to the procedures that is set by the company. All right. And it is also very important for the staff to understand that what is the periods that they are entitled to. So if your company says, well, in terms of absenteeism, we require you to let us know on a Monday and a Friday after or before a public holiday. We need you to submit a medical certificate because of a pattern that was identified in staff previously. And that is part of our policies and procedures. All right. So what is it that you are wanting from your employees? So that is why it's so crucial for an employer to implement a proper absenteeism policy, that it actually states what is the requirement, and if this is not followed, then what is the consequences after that, following from the non-adherence. All right, and then I also touched base on the requirement to immediately report absenteeism. What is your company policy say? Does it say if a person was booked off for a week that they submit their medical certificate on the first day of absence and they notify you as they go along? Or is it sufficient for the company to notify you on the first day and then submit the medical certificate for the week and then no further communication is needed? So that is very important for you, for the people to understand, actually for the staff to understand what is required from you as the employer in that instance. All right. Then keep accurate and formal absence records. Is there anybody that can tell me why it's important for a company to actually keep accurate and formal absence records? Anybody that wants to take a stab at it? All right. Okay, so it's firstly important because when you have an inspection from the Department of Labour, they would actually ask you for an attendance register to show that the staff was actually present or absent, and then you need to actually show them that there was a proper attendance register taken for the staff. It's also important in terms of health and safety requirements, in terms of, let's say there was a fire at the workplace and you need to account for the staff that was actually present on the day or absent. If you cannot do that, you find the risk of having people that you cannot identify, and should there be a fire or any incident at the workplace and you cannot account for all the staff, then it will be a huge liability on you as the employer. So it's crucial for you to keep records of any absences or present staff that is present at the workplace, especially for this type of scenarios. All right. It's also important, as we indicated earlier, to identify patterns of absenteeism. Obviously, it's important to also know at the end of the year, there are a lot of employers that have 4 shutdowns over December period, especially in the construction industry. So you need to keep a record to make sure that sufficient leave days are available for the various staff members. For instance, if you can see somebody has a minus or a negative in terms of their leave balances, then obviously you need to have a discussion with the employee at the end of the year to determine how the leave will be taken. All right, so what does your policy again say in terms of inadequate leave for leave periods? Are you allowed to go into a negative? If so, how many days can you go into a negative? And then what is the payment option in terms of your leave period? Should an employer resign, what is the maximum amount of leave that is payable at the end of that period? So it is crucial for you to keep accurate records of any absenteeisms. All right, and then escalation of repeated patterns of absence through progressive discipline. As we indicated earlier, it is crucial for you to keep these records so that you can actually start tracking the staff members to see who is abusing their sick leave and who is needing to go on holiday because they are facing a probable or possible burnout period. All right, it's crucial. That is why the law actually gives us annual leave. All right, so to make sure that the staff actually manage that correctly, to make sure that they do take the leave that is required. All right, so that is important for you as managers to make sure that you actually track these records of the staff, and then should you find that somebody is abusing their sick leave, or if you identify a possible case of incapacity, that you immediately report that to your human resources for them to then take further progressive discipline in that regard. All right, I don't see any hands coming up, so we'll go to the next section.
Okay. Like I've mentioned before, when an employee fails to report for duty and they even fail to give, sufficient notice to the employer, you as the employer now will find yourself struggling to maintain productivity in the business. You struggle to meet deadlines or finding a replacement, or even when it's time to find that replacement, it's going to cost, the business money to find such a replacement. So that's why we are saying that absenteeism is not just an inconvenience, it does have real operational and financial impact to the company. So you need to make sure that you are aware of what the employee is going through. You'd find that there's an employee that's pregnant, or they have a contagious disease, or we need to be aware of such sicknesses, because also it can cause low morale amongst the staff as well, where now people are finding themselves having to take on so much work of the other employee that's forever absent at work, and it discourages them, and it puts a burden on them. Also with meeting deadlines, you find that there's clients that are waiting on orders, and because you keep on experiencing the same things, low morale and production delays, it does affect the business to a much higher note. I don't think that this is something that should obviously be taken lightly. So because that's the whole aim of the business, to provide great service to your clients, to your customers. So if now we find ourselves having to struggle internally, with keeping up to date with the absenteeism of the employees, it becomes a struggle. So that's something that we need to take note of. So the employees are entitled to paid sick leave. That's law. That's nothing that is out of the ordinary. However, there are rules with the BCEA in that in a 3-year cycle, there's only so much sick leave a person can take. So in a 3-year cycle, which is 36 months, a person is entitled to the amount of leave that is equal to the number of days they would work in a 6-week period. So if someone is working 5 days, then it's 30 days. But if they work Saturdays as well, or 6 days a week, then it's 36 days that they are entitled to within that whole period of 3 years. However, it's also important to note that for the newer employees that have been employed for less than 6 months, they are not just entitled to the whole 36 days, 30 days or 36 days immediately. They only get 1 day for every 26 days worked. So that's also something that to keep note of. It's important. A medical sick note can be required, is required, in fact, for sick leave, so that we can prove that there was proof of illness. That's where the validity or the relevance of the sick note comes in, that the person was not well, was unfit to perform their duties. Like Claudine has mentioned before, it's important to have a clear policy that regulates when a sick note can be submitted or when it should be submitted. For instance, the Mondays and the Fridays, we know people can, employees can take an advantage where they want to extend their weekends. So in order to manage it, we need to have, clear policies that are in place.
If I can just also jump in here, I think it's also important to know that some industries or bargaining councils actually do limit the sick leave of 30 days to say that, listen, in terms of our bargaining council agreement, you can only take 10 days per year. Whereas the basic conditions of employment does not have a regulation in terms of how many days you can take. So let's say I am injured in the first year and I want to take my sick leave. I was in a car accident and now I want to take my sick leave. I can use my full entitlement in the first year, meaning that over the next 2 years, I won't have that option. But in terms of the bargaining council for the motor industry, they do actually put a cap on it that it's 10 days per year. So it's very important for you as employers to know which industries you fall and make sure that you are aware of the bargaining council's main agreement, because sometimes the main agreements do differ from the Basic Conditions of Employment Act, and you need to make sure that you are aware of the difference before you actually draft your policy and implement it accordingly. Thanks. Sorry, Caitlin.
Any questions on how the sick leave based on the Basic Conditions Employment Act works? Okay, moving on.
All right. So this is also a very important point to note, which is also an important point for your policies when you look at unpaid leave and when it can actually be used in terms of your company policy. Obviously, for me, myself personally, I find unpaid leave taboo. I don't think that unpaid leave should be something that is used for staff to get additional days. I think it is something that needs to be used in exceptional circumstances for staff, and it should be noted like that in your policies. So unpaid leave is really when a medical certificate has not been provided for unauthorized absence, meaning that if somebody had taken 3 days off work due to illness and they cannot submit a medical certificate of any kind, then obviously that is regarded as unpaid leave. It is up to the employer if they want to allow the person to take annual leave, but obviously unpaid leave in that instance will suffice because it's also a deterrent for the employees not to do the same thing again in future. All right. When a medical certificate does not confirm incapacity, meaning, and we are going to touch on that later, to say that if there was an attendance certificate to show somebody attended either a dentist or a physio, but there was no incapacity, i.e. the person was never booked off work, then that cannot be regarded as a proper medical certificate and is seen as unpaid leave. All right. Then Caitlin also earlier talked about the fraudulent and altered certificates. Obviously, if the company can prove that, then they don't need to pay for that. Just make sure that when you accuse somebody of fraudulent sick notes, that you have either confirmation from the medical practitioner that was noted on the medical certificate, or that you get confirmation from the National Institute for the Professional Health Council of South Africa that the practitioner that was used is actually not registered. All right, so you need that confirmation when you want to take further action. You cannot just because a date was changed from 23 to 28 assume that it was altered and it's fraudulent, because that has come into dispute a few times with myself personally, where the company then faces an award that is not favorable in that instance. All right, so just make sure, but there are websites that you can visit. If you want us to give you the website, you are more than welcome to ask that afterwards, and we will provide that to you, where you can actually verify the medical practitioner's practice number to actually see. Sorry, we've got a question. Is a clinic note seen as a sick note or as unpaid, has not been booked off?
We are going to touch base on that very soon. Yes. Just hold that question.
All right, so that is actually one of our slides that we are going to touch on. But thank you so much for your question. That was a brilliant question, and we are going to touch on that. All right. When the employee exceeds their entitlement, all right, so that is also an important point to note. And that is why, remember earlier when we said that it's important to keep a record of the absenteeism, this is why, because it allows you that opportunity to verify whether or not the person does still have sufficient leave in terms of his sick leave. If not, then it's regarded as unpaid. Yet again, the company can decide whether or not they want to give annual leave in those instances. But if your company policy says if you exhausted your sick leave, then it's exhausted. Obviously, you also need to look at injuries on duties. Just remember, an injury on duty cannot be claimed as sick leave on your system. All right. A lot of companies do say that they have a special leave bar that they can use in those instances if it's an injury on duty. All right. And then absence unrelated to illness, that is also regarded as unpaid. As we said earlier on, any unauthorized absence that the company didn't give authorization for, that is regarded as unpaid leave. So just be aware of that. But like we said at the very beginning, I think it was the third slide, where we said, understand what is absenteeism. So make sure it doesn't fall under the ambit of family responsibility leave or sick leave or annual leave or anything to that effect. So you just need to make sure that your policy governs everything in this regard. Again, if you need assistance with anything like a policy implementation, you are more than welcome to contact us afterwards. All right, and right, then when we look at valid medical certificates, it's crucial for you when you actually look at the medical certificates to make sure that they are issued by a registered medical practitioner. And as I indicated earlier, there are websites where you can actually validate the practice number to make sure that the person is really a registered medical practitioner. All right. If you can't see it on the website, then you can contact the National Council for the Professional Medicals. All right. Then include the practitioner's details and registration number. This is important because this is the only way that you can actually see whether or not the medical certificate was valid or not valid. And then you can also contact the person. And in some instances, we've had employers that actually drove to the practice to make sure that it's actually there. And believe me when I tell you, there are instances when they actually have driven to the place and there was nothing there. It was a bare stand that was just there. So yeah, it's important to look out for these details, and then just to confirm the address, the telephone number, the email, and then the registration number. All right, then confirm that the examination actually took place. We also have issues where people ask us, is telephonic medical consultations accepted? Well, yes, if the doctor is valid and registered and he did book the person off for a certain amount of time, then yes, unfortunately, you need to accept that. All right. The medical certificate furthermore needs to confirm the unfitness for duty, the period and the nature thereof. Obviously, they don't need to declare whether or not it was a migraine or a headache. They can just state medical condition unless the patient actually agrees for them to disclose the nature of that. Obviously, if you go into incapacity, like I said earlier, that changes, and you can, as an employer, request that they actually make known to you what the nature of the illness is. All right, and then it needs to be signed and dated properly. That is probably where most people fall into the pitfalls when they do make an adjustment on the notes, where they forget to actually update the date that is signed at the bottom. And that's how most employees are caught, when they do the adjustments, but they forget to adjust the bottom part where the date is actually written down. All right, so in terms of that, I think that's very self-explanatory, but if there's any questions in regards to that, you are more than welcome to ask us. And then just finally, from my side, is it's important, a sick note is proof of incapacity. All right, so the person must be incapacitated for a period of time for it to qualify as a valid medical certificate. Thank you very much.
And in other words, just to add on that, it just means the person must have been unfit to perform their duties.
Perfect. Thank you so much, Caitlin.
All right. Okay, so when it comes to fraudulent and invalid sick notes, there are a few things that we obviously should take note of.
There's a question. Yes, Daveen.
Pansula asked a question in the chat. Will you guys just please have a look at it?
Oh, sorry about that.
Okay. In terms of antenatal visits, appointments, would this be because of this? Oh, right. Okay, we are also going to touch on that. Thank you so much. We are going to have a look at that later. It's one of our slides, actually, that we are going to touch base on in terms of pregnancy checkups. All right. Thank you so much, Pansula, for your question.
Okay. All right, going back to invalid sick notes, there are a few things that you as the employer should take note of when it comes to verifying if whether this is a legitimate sick note or not. For one, you need to check for the registration number. Obviously, if it doesn't exist, medical practitioners also have laws that they need to keep up with from their side, in that if they have a sick note, it must provide their details. So their registration number should be on there, which can also be verified on their council's websites, where you can just type in their registration number and you see if whether this is even a registered medical practitioner. Backdated without consultation. We have seen it before, where employees choose to make a 2 and 8.
Too much. Yes.
Yeah, understand. So you also need to check on that. It's not allowed. They shouldn't be bringing sick notes that have been altered by pen, because chances are they did that themselves in their house. Generic or pre-signed forms where they just get something from the internet and they just choose to write it on with a pen by themselves without a stamp, without any details. That's something that you should be careful of. Like Claudine has also said, you can accept it and you just pay it out as an annual leave, but we would suggest that you just strike that as an invalid sick note. Altered or purchased sick notes. We know there are doctors all around, especially in Johannesburg, where you just go there and it's 200 Rand. Please take note of that. You can verify them. Again, some employers do even take the time to visit at the premises of the doctor to verify this. A fraudulent medical certificate may justify dismissal. This does not mean that when someone has submitted a fraudulent sick note, you can just say to them they should leave. No, there should be a procedure that is followed, a disciplinary inquiry and a proper investigation. But it can, if it is proven that the employee kept on submitting invalid sick notes, but a procedure must still be followed. Yeah.
All right. So if I can also just go back to backdated without consultation, you don't need to accept that, as Caitlin indicated. So when it's backdated, I mean, how could the medical practitioner reasonably have assessed the person in terms of the dates prior to him actually consulting him? If it's a day or two, I would say, yeah, you can consider that. But I mean, if it was a week in the past, I mean, it's very difficult for the medical practitioner to have actually examined the person and decide whether or not he was unfit for duty. So just be aware of backdated consultations in terms of that.
Okay. Traditional healer certificates. It's common that at times an employee will be absent from work, and when they return, they will claim that they were unwell and they did not visit, for lack of a better word, a modern doctor. And then they will say, no, they went to a Sangoma, again, down the road. I'm happy to tell you that there's a council for traditional healers, and traditional healers should be registered under that council in order for them to issue out sick notes. So that's something that you can also verify if they do bring such a sick note from a traditional healer. That's something you as the employer as well can just investigate, see if whether it's real or not. But employers, you can accept it if you see that, oh, okay, no, it is a registered traditional healer. If it's properly dated, if it confirms incapacity or unfitness for duty. People, I mean, cultures are different. People do consult the traditional healers for various different reasons. But when it comes to a sick leave, it must confirm incapacity. So if the employee has went to see a traditional healer because they felt that their house was haunted, it does not mean that their unfitness for duty was, impaired. So that's something that you should keep note of when it comes to traditional certificates. It is real, it happens, there is a council, but we must verify it.
Yes, for sure. Thank you, Caitlin. All right, and now Anthony, to answer your question, does clinic notes constitute as proper sick notes or medical certificate? Well, if again they are booked off, if they are incapacitated, then yes. But if the clinic note merely states that they attended the clinic, then no. All right, so in that instances, you do not need to accept the clinic notes unless, once again, your policy states something different. I know that a lot of times, unfortunately, South Africa's clinics are overloaded with people going there, and then in terms of the amount of staff that's available. So I do know that people sit there sometimes for a full day without being seen. So again, that is something for the company to decide in terms of whether or not you're going to accept an attendance slip from the clinic to say that the person was there at the practice. All right, but in all essence, you do not need to accept it because it doesn't book the person off duty. All right, so they are not declared unfit for work, as Caitlin earlier said. So yeah, in that instance, no, you don't need to, and it's regarded as unpaid if it's only an attendance confirmation. If, however, the sister or the doctor or any medical practitioner booked them off for a period of time, then yes, you need to consider that. All right.
Just to add on that, Claudine, we're not saying the clinic does not have medical practitioners. We're not saying that, but we're saying it does not automatically mean that the employee was medically unfit to come to work. So that's the difference. Remember, we said it's important for the sick note to confirm proof of incapacity.
Mm-hmm.
Yeah.
All right. Thank you. And then leading on from that, I know this happens a lot as well, where the people would actually give you their blue card or their clinic certificate to say that they need to. Yes, Albert.
Apologies for the interruption. I just saw another question pop into the chat on that topic, and I thought before we move on, we can just answer that one. Thanks so much.
Oh, thank you. Oh, Anthony, so if they're collecting, for example, chronic meds, then is it annual? Oh, right. Thank you, Anthony. You are actually just anticipating what we are going to tell you next. All right. So yes, that's exactly the next slide is in terms of collection of medication. Obviously, if they collect the medication, still they are not booked off duty, meaning that it does qualify as annual leave. You are 100% correct in doing that. So it does not automatically qualify as sick leave because there was no incapacity confirmed. The person was never booked off work for a certain period of time. Also, one needs to consider your operational requirements. So Obviously, it's required for people to actually notify you in advance, because I know for a fact that people know in advance, about a month in advance, that they need to go and collect their medication, especially from a clinic, and then so they could have informed you a month in advance. If the company's policy states that you get 3 visits per year to the clinic to go and collect your medication, and you allow them to take that from their sick leave, should they have any sick leave available, then it's your prerogative as an employer to do that. So it's very important, yet again, I'm going back to the policy. So it's very important for the policy to be firstly implemented and drafted correctly, so that going forward, everything is written in the policy so that you can apply that policy consistently, and that there's no questions in regards to what is the requirement of the company in terms of your specific operational needs. All right, so drafting the policy is very, very important. I think sometimes people overlook that importance in the workplace, because everybody knows absenteeism, everybody thinks they understand how to manage it in the workplace, but when you start delving deeper into what is absenteeism in the workplace, and what is the requirements, and what is allowed, what is not allowed, what is the consequences if I don't do that, what is the reporting timeline, if you consider all these things, and if it's not written anywhere, on what basis are you going to discipline your staff? So if there's no policy in place, then you can revert back to the basic conditions, but it doesn't address your operational needs as a business. So that's why it's important to draft a policy that's specifically catered for you and your company. All right, so there was another question by, is it Hortensia? Sorry if I mispronounce it. So if a person has taken a day off to go to the clinic, should that be considered as annual leave or unpaid leave? Okay, yet again, so if the clinic, if the sister or the medical practitioner booked them off for a day or 2, that is sick leave. If it's only to confirm that they attended the clinic, and you know that there's normally an attendance slip that you get from the clinic, that is not considered sick leave and should be taken as annual leave or unpaid leave. So once again, that is the prerogative of the company. Are you going to accept it as annual leave, or is it going to be unpaid leave? Obviously, if the person has enough annual leave, then one can assume that the person will take annual leave in that instance. If there's not enough leave available, then it will be regarded as unpaid leave. But yet again, that should be noted in your policy when you draft the policy. All right, and I think we're going to address Pansula's question next in terms of the pregnancy checkups. All right, so it can qualify as sick leave if it is a medical necessity. I think a lot of women will agree with me that a doctor can book you off work if they feel that it's a danger for the pregnancy, and if so, then obviously that will be regarded as sick leave. If it's only for you to go for a checkup with the doctor, then normally that is required in terms of your annual leave entitlement. But yet again, that is something that the company needs to decide on when they draft the policy. So in your policy, you can say, when a female employee gets pregnant, the company will allow for 3 doctor's appointments in the term of her pregnancy. All right, so that is up to the company to do that. But yet again, if we strictly look at what the law says sick leave can only be taken if unfit to perform duties. So going to the doctor for a normal checkup, as you do for a clinic visit, that is not regarded as sick leave. All right, so in that instance, again, it is so important to put all of this in your policies to avoid any disputes that might come across your table. All right. And then also, as we said here, reasonable accommodation may apply. So it's always important for you to sit around the table and decide how many days do you want to grant a female employee, or are you granting the female employee a certain amount of hours in terms to say that you can go for the checkup in the morning, but we need you back in the afternoon. So we grant you X amount of hours or X amount of days, but that is something that you need to decide. And just remember to implement this consistently. You cannot for a senior person say, okay, listen, you can go quickly and go to the clinic, but then for the person that is sitting at reception say, oh no, unfortunately, you're going to have to book that as annual leave. So please be consistent in regards to that. And then, like we also say, to avoid any claims of discrimination when you look at that, especially because it's a pregnant employee. You don't want to sit with a claim of unfair or automatic unfair dismissal, or discrimination in terms of the fact that she's pregnant. All right, so that is something that you need to consider when you look at drafting your policies again. So it's so crucial when you do the policy to sit actually and take the time to draft it, because you need to consider all these various aspects and the operations and the nature of your business. And also, like we said at the very beginning, just take cognizance of the nature of the collective agreement. Okay, what does the collective agreement say if you fall within a bargaining council? All right. Thank you.
Okay, identifying sick leave abuse. So if you as the employer suspect that there's an employee that is abusing sick leave, it is important to be cognizant of how to address the issue fairly and carefully. We obviously, like, there would be patterns that you should look out for, like I've mentioned before, the Mondays and the Fridays, the paydays, the public holidays where people just want to extend, their long weekend or want to have extra days, or rather short-term sick leaves without any proper medical explanation. For instance, Claudine mentioned earlier, the absence within an 8-week period. We should take note of that if you're going to be so absent within that 8-week period, surely there is something wrong that the employer should be aware of. So if now there is no medical, true explanation, then it's very important to be careful on how to address the situation. Obviously, from our side, we would suggest that you investigate the issue, you meet with the employee, address your concerns, and if now you can see that there's dishonesty involved, then disciplinary action is definitely recommended. Obviously, still keeping within the boundaries of the labor, legislation, and following a fair procedure. But those are the small patterns that you can look for when it comes to, identifying people that are abusing the sick leave, especially without any proper or reasonable explanation. Yeah.
All right. So as Caitlin indicated to you, those are the points that you need to identify the abuse of sick leave. And then we go back to when we said it's so important for you to keep a record of absenteeism and leave, etc., so that you can keep a record to say, I can now identify that over the past 6 months, I can see clearly that there's a trend in you abusing your sick leave, and there's no justifiable reason for you to actually do that. So there's no chronic illness that would justify you to consistently take so much time off in terms of your sick leave. And you can show that there's a pattern in the sense of it's always on a Monday or it's always on a Friday. So as soon as you can see those patterns, then you can address the sick leave abuse. Just remember that there's a big difference between misconduct and incapacity. If the person can prove that they have a chronic illness, let's say they've got TB, for instance, and they have to go to the clinic often, they are very sickly most of the times. If they can show that there was a chronic illness, then we rather look at incapacity instead of misconduct. But when we can show that there was sick leave abuse, to say that, listen, this person is always off on a Monday or a Friday, and the sick leave notes is either medical condition, the next one is a stomach ache, the next one is diarrhea, we can clearly see there's a pattern where this person is not really chronically ill, but they are rather abusing the sick leave. Then we need to start addressing that. How do we address it? We call them in for a counseling session. We have a meeting with them to identify what are the issues. We need to look at all the sick notes. Was it issued by the same doctor? Was it issued by different doctors? Then we issue a letter to say that, listen, we need clarity from the doctor to say what is actually wrong with you. So what is the nature of the person's job? What is the issues pertaining to these illnesses? Is it permanent? Is it temporary? Could there be any underlying issues that is actually making this person sick that we need to identify? So that is what the counseling session is for. And then obviously after that, then you can go through your disciplinary process to say that, listen, I'm charging you now for abuse of sick leave because I can prove it. There's a pattern, there's a clear pattern, and then your sick leave medical certificates doesn't actually correspond, showing that you've got a chronic or underlying illness that is preventing you from coming to work. And then you obviously need to follow a fair process, and that is where you will get your human resources to come and actually assist you in regard to that. Also ensure that you remain consistent when you do this. So you cannot do it for one employee and not for the other. So that is why it's important to keep a record, because if there's ever any disputes in regards to consistency, the company can actually show in terms of their records and show every single person in the company's record to show that the reason why Caitlin was singled out is because she started showing a pattern of abusing a sick leave, and why Claudine was not called into a meeting. So you need to be able to actually show that why was one person singled out and not another person. Okay, so you need to indicate where the pattern occurred and if there was any counseling that followed from that. Anything from your side?
There is a question.
Oh, Anthony.
Does an employee have to disclose if they have a chronic disease? We understand that there is confidentiality between the doctor and the patient. However, when we now get to a point where we need to address such issues because it's affecting the pattern or the operations of the business, then yes, you can request the doctor to disclose of certain information. We're not saying they must disclose of confidential information, but in order for the business or the company to address, the sickness or the unfitness of the employee, then there would be certain information or report that would be required from a medical practitioner. So that's why we are saying sit down with the employee so that it can be addressed. You can even draft a letter, which sometimes we do, to the doctor to say, these are the duties of the employee. She has, for instance, back pain. She's standing 9 hours in her job. So how do we deal with it, going forward? That information you can request from a medical practitioner.
Yeah, if I can just add to that, Anthony, if a person, I don't know what your onboarding process is like, but normally with the onboarding, there would be a form normally where the person actually completes to say they want to state whether or not there's any medical conditions that will hinder them from performing their duties. Obviously, they need to disclose that when you do your appointment documentation, so that they actually disclose if there's any chronic diseases that you need to be aware of, so that you can make the necessary adjustments in the workplace should it be necessary. Obviously, if it's during the course of the employment, as Caitlin mentioned, then yes, you can disclose it. But obviously, in terms of a chronic disease, if it is something that, as I mentioned earlier, if it's TB, if it's something that can be contagious to other employees, yes, for sure they need to disclose it. I mean, during COVID time, we saw that it was actually a criminal offense when people failed to disclose to the employer that they have contracted COVID. So there are certain chronic diseases that people need to address and disclose to the employer, but it all depends obviously on the situation. But somebody cannot cry that they have a chronic disease when you accuse them of abusing sick leave if they never disclose that to the company. All right. So disclosure is also the employees and the employee's responsibility to make sure. And that is why it's crucial, once again, to refer back to the record keeping so that you can actually track to see if there's a pattern in terms of that. But yes, normally in your appointment period, you would ask the question, is there any medical condition that the employer needs to be aware of that could prevent them from performing their duties? All right, so that is very crucial for you as an employer to have that documentation in place. And then obviously in your absence policy, you would also then note, if you are diagnosed with a chronic disease, please disclose that to the company so that reasonable accommodations can be made for you in the workplace if available and if possible. All right, so yes, and then the next question from Elsie.
If an employee is constantly taking a child to the doctor or hospital, is it seen as unpaid leave or family responsibility leave? Okay, so with family responsibility leave, the BCEA only provides 3 days per year. Some employees, in their policies, they would increase it to 4 days or 5 days. Obviously, it's at the discretion of the company. But if an employee has now exhausted the family responsibility leave, then they cannot have any additional days unless the company obviously will allow, a negative days
Balance as well.
on that, yes.
Mm.
So again, if there is no family responsibility leave, then it can be seen as annual leave. I don't know if you have
Yeah.
a different view.
Yeah, also, Elsie, obviously, if it's becoming a problem for the company, if somebody's taking consistently their child to the doctor or the hospital, I understand. I've also got children. It does happen. But if it's causing operational disruption, then it needs to be addressed. You cannot take your child to the hospital or to the doctor every single week, because it's going to start impacting on the work, okay, and on the colleagues. And as Caitlin earlier indicated, it's going to have an operational, staff morale issue, a financial impact. So it's going to have a lot of impact if staff are starting to abuse and habitually taking absence. All right, so that is why the law gives you 3 days of family responsibility leave when your child is sick and needs to go to the doctor or the hospital. But if it's a consistent pattern that's occurring, you need to go and sit and have the counseling session with the person to say that it's becoming a problem, and obviously we need to address it. Because to say that we are just going to give the person unpaid leave for the next 10 instances, that's not going to rectify the problem, because the problem needs to be addressed in the sense of, why are you taking your child to the doctor so often? Do you not have a support system in place? Was this ever disclosed to the company initially? Why didn't you make a plan now to tell us that there's a problem so that we can try and assist you? But we need to sort this out. So yes, if the family responsibility leave is exhausted, then you can look at unpaid leave. But like I said earlier, unpaid leave is taboo really for me personally, because some people don't mind taking unpaid leave. So for me, that's really the last case scenario. So when your family responsibility leave is exhausted, then you can look at annual leave. And when that is exhausted, you look at unpaid leave. All right. But before you get to that stage, you need to start doing your counselings with the employees to see what is the reason and the cause for this happening. Why is the person constantly taking their child to the hospital or to the doctor? Or is there anything that you can do in terms of, I don't know what the nature of the illness is of the child might be chronically ill, but then you need to start addressing that as well. So you need to get to the bottom of what is actually going on, because this is going to have an impact on the company going forward, and then obviously on the other staff members. All right, then as we said earlier, myself and Caitlin, is that we need to look at the best practice for employers. And where do we start with that? We start with a clear absenteeism policy. I cannot express to you the importance of having a policy in place that actually sets out your company's procedures, your entitlements, what is required of the employees, and what is the consequences if this procedure is not followed. And this must be consistently enforced. What we normally do is we ask the people to have workshops with the staff so that they are actually aware of what is expected of them in terms of the policy, because sometimes people don't read the policies, especially if it's more than 2 pages. They tend not to just read it. So it's very important for you as an employer to have a workshop with your staff, especially on issues like this, because it can have a detrimental impact on the business going forward. All right, and then, like we said, maintain proper and accurate records. Not only is it a requirement by law, but it is essential for you as an employer to keep a record of what is actually happening with your staff and identify possible issues that might rise up. And then early intervention, like we said, if you can see a pattern occurring, do an early intervention with the people, get them in for a counseling session, find out what's going on so that we can take action. It doesn't help that the person has now taken all their sick leave in the first year, and now you say to us, listen, we want you to dismiss this person because they have abused their sick leave, but nothing was on file. So early intervention is crucial for you to actually sit down, have the counseling session so that you've got that on record, so that when you want to take progressive discipline further, then we've already got the baseline for that. All right. And then it's essential for you to make sure that your HR and supervisors are trained on how to deal with these issues. So make sure that they are trained on the absence policy, make sure that they are trained on the disciplinary policy, make sure that they are trained on incapacity procedures, so that when stuff like this arises, that they can address it quickly and efficiently to make sure that you don't have disputes arising in the workplace. And then obviously what we always say is seek advice before you dismiss. All right, to make sure that there's never an award against the employer that is not favorable. All right. And I think,
yeah. And just to add a bit on the absenteeism policy, we do understand that there's different sectors of businesses, there's different issues that absenteeism gets to have on the business. So obviously, employers should just be cognizant of the fact that not everything is going to be the same for the next business as well, because truly it's different sectors. It's construction, it's retail. Such will not be, be weighed the same way or be treated the same way, because it has different, effects on the operation and even financially. I mean, there are businesses where if someone is absent, life can go on, the business can proceed. But for other sectors, if someone is absent, it does have, some negative effect. So
yeah,
different sectors. Yeah.
And just leading on from what Caitlin has said, as we indicated earlier, the bargaining councils, make sure that you read the bargaining council main agreement, because I'm going back to MIPCO, the main agreement for the motor industry bargaining council. Their family responsibility leave is more than what the basic condition is actually stating. So make sure that you understand the council's agreement. So when you draft your absentee policy, that you're not in contravention with what the main agreement is saying, but that you're actually aligned with what that agreement is saying. So yeah, so if you need advice on that, please let us know. We will gladly assist in that regard. But thank you so much for your time and for your questions and for your participation. And we open the floor now for any further questions.
We do have a question.
Oh, yes.
Do absenteeism policy have to be signed by employees or just displayed?
All right, so it's always good to have a policy signed because it does protect you as an employer. But saying that, if in your contract you state that it is the employee's responsibility to ensure that he familiarizes himself or herself with the policies of the company and to make sure that you've got a register or a list of policies that is available, but then just make sure that those policies are available for the staff, so that when you've got your list, I always say have an annexure at the end of your contract to say that the employer has X amount of policies, and please make sure that you read these policies, and it can be obtained from your manager or HR, and then have a policy manual where all the policies are printed and put in that manual. If you've got an intranet, great, then that people can actually go and look for it on the intranet. But yeah, it's first prize to have it signed. But then obviously, if you can't do that because it is tedious to print out a long document for every single person that's employed, have it in your contract and make sure that there's an annexure at the back that actually has all the policies contained in there, so that when there's a dispute that arises that you refer to the policy, that there was a breach of this policy, then you can say, but sorry, it was contained in your contract, you signed for it, the policy was clearly noted at the back as annexure A, and the policies are readily available at the HR office or at my manager's office in a document, either a printed document, or it can be available on the intranet.
Albert, your hand is up.
Thank you very much. I must apologize from the onset because ironically, during the webinar about absenteeism, I was temporarily absent on a phone call. So I'm not sure if this was canvassed already, but what is your view on virtual appointments with doctors, assessments with doctors? We recently had a member where we advised them not to pay on the sick note because in that particular matter, the sick note stated that the person was assessed in person or physically assessed, something to that effect. And we found out it was all online, so it wasn't the case. It was a misrepresentation. So we argued we could get away without paying on that sick note. But in a general sense, what is and I know this is a world that's changing rapidly and more things are going online. I myself don't have a clear-cut answer on this. I think it's contextual. But what's your view on the submission and reliance on sick notes where it's clear from the get-go that it was an online consultation?
Well, from my viewpoint, it needs to be, if you purely look at what the law says in terms of what qualifies as a medical certificate, and whether or not it be a telephonic consultation or a virtual consultation, and it is legitimate, not as in your instance where there was misrepresentation, but if it's a legitimate sick note and the person was declared unfit for work, whether or not being physical, telephonically or via virtual consultation, then it should be regarded as a medical certificate and the person should be entitled to sick leave. I think this all changed during COVID, when people were not allowed to go into the medical practitioners' offices due to the proximity of touching people, etc., etc. So I think all of that changed, and there was never anything in legislation that said we cannot do that. It's not allowed, and that was never changed to say that currently, as we're standing now, it's not allowed for people to actually do that. So unless there's new legislation published to say that you cannot accept a virtual or a telephonic consultation, even if you book on Intercare, for instance, there's the option for you to actually book the telephonic, and obviously they are governed by law as well. And I don't think that that would be acceptable practice for them to actually make that available to the patients if it's not an acceptable practice and if they're not allowed to book the patients off due to that. So that is my opinion, to say that, well, if it's virtual or telephonic, then obviously it needs to be accepted. If it's valid, signed by a medical practitioner or issued by a medical practitioner that's registered, and the person was actually booked off duty.
Thank you very much. I suppose it also depends on the context. I mean, if a sick note, I suppose, is saying that a leg is broken and the person wasn't actually physically assessed, then how can the doctor say it's purely based on the word of the patient? Whereas if it's a head cold, yes, normally with a head cold, they would only rely on the word of the patient. But I suppose there are certain ailments like a broken leg where you can challenge it, because how could they come to that prognosis or that diagnosis without seeing the person? So it's very contextual from what I'm understanding.
I 100% agree with you in that aspect. 100%, yes.
And obviously, we're
Awesome.
also not saying that misrepresentation is something not to be frowned upon, because then if the doctor himself is saying that the person was there physically, that is something that should definitely be frowned upon by the employer.
Thank you.
Yeah.
Elsie, I see that you asked a question. If you can send me your email address, then we will definitely contact you afterwards to have a discussion with you. You can just put your email address in the chat box, and then we'll make contact with you after the session. Thank you so much. All right. Any other questions from any other person? All right. Then our side,
I think we did a lot of the questions and answers piecemeal.
All right. But thank you so much for this
session. There's a bit of a lag. I think Elsie sent her. Thank you very much for your time to our wonderful presenters. It was a very informative, very interesting topic. Just extending the invite to members. They're welcome to contact us just to answer any queries they may have. Also, with regard to Elsie, to send their codes, etc., we can just assess them and make sure everything's up to scratch. But thank you very much, ladies, for your time. It was truly very informative, and yeah, I wish you all the best, and I hope all our members have a wonderful day. But I see before we log off, Daveen's hand just went up.
Hi, Albert. Pansula asked the question whether they can receive the websites where they can verify their sick notes.
I think what we will do is we can publish it on SMIEO's website, and then everybody can have a look at the website.
Also, it's not verifying of the sick note, we're verifying the medical practitioner,
Yes.
if whether the medical practitioner exists or not. Yeah.
I just wonder, is it not a URL we can maybe paste now or email to members after the webinar? Do you have that ready by any chance?
Yeah.
Yeah, I don't have the website now currently on hand, but that's why I said we can publish it later, either to the members on the website. Yes.
Thank you. All right. I think that's everything then. Thanks everyone for joining us today, and all the best. Have a wonderful day. Cheers.
Thank you so much, everybody.
Thank you.
Have a lovely day. Bye.